Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
Imagine buying a brand new car, fresh from the dealership, only to find out that it jerks or stutters with every change of gear the moment you drive it home. That was the experience of Marilu Tan, who in 2016 bought a Fortuner from Toyota Balintawak Incorporated for almost 1.5 million pesos. She immediately informed Toyota of the vehicle's condition. However, instead of getting a replacement, Marilu was told by the sales agent that the vehicle may have been stocked up, so using it in time could make the defect disappear. But the car's jerky movements did not go away. After Toyota Balintawak's technical department inspected the vehicle, Marilu and her husband were informed that there was a defect in the vehicle's transmission. They were also told that there was a need to replace the transmission assembly and to reprogram the engine control unit software at no cost to them. Marilu demanded that Toyota Balintawak either replace the vehicle or refund the money she paid for the same. What followed was a long legal battle that would eventually reach the Supreme Court. When a brand new car turns out to be defective, which law should protect the buyer? Republic Act No. 7394, also known as the Consumer Act of the Philippines, or Republic Act No. 10642, or the Philippine Lemon Law? Are these laws mutually exclusive? Or can a consumer choose between the two? How should the rights of vehicle buyers be weighed in relation to those of car manufacturers and dealers? Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 12th of December 2025, and today we talk about laws that protect consumers, particularly Republic Act No. 7394, also known as the Consumer Act of the Philippines, and Republic Act No. 10642, also known as the Philippine Lemon Law. These within the context of the case of Department of Trade and Industry or DTI versus Toyota Balintawak Incorporated and Toyota Motor Philippines Corporation, GR numbers 254978-79. This case was penned by Associate Justice Antonio Tico Jr. and decided by the Supreme Court 2nd Division on October 11, 2023. And with us today to discuss this case is Attorney Jose Maria G. Hofileña, member of the Commercial Law Department of the Philippine Judicial Academy. He is also the Dean of the School of Law of the Ateneo de Manila University. Hi, Dean Joey. Welcome to the Supreme Court Podcast, and thank you for inviting us to your office here in Rockwell.
Hi, Mike. Thank you very much for the invitation to join your podcast. It really is a privilege and an honor.
The privilege is ours, Dean. Dean, can you please give our listeners a short introduction to Republic Act No. 10642 or the Philippine Lemon Law? Why did our lawmakers see the need to have this kind of law?
Well, the Philippine Lemon Law or Republic Act No. 10642 is in that class of consumer protection laws that are intended to provide rules with respect to how consumers can protect their interests as buyers of products or services against businesses and trade practices that are deceptive, unfair, or otherwise inimical to consumers and the public interest. The subject matter of the Philippine Lemon Law, however, is one that zeroes in on brand new motor vehicles. In other words, the Philippine Lemon Law protects buyers of brand new motor vehicles in that it affords them remedies in case the brand new motor vehicle that they had acquired experiences any defect or condition that impairs its use or value or safety. And the remedies are assertable against the manufacturer, distributor, or dealer of such brand new motor vehicles. Well, note has to be given, of course, that the reference to motor vehicles in the Philippine Lemon Law is not comprehensive in the sense that it applies only to the vehicles designed to carry a limited number of passengers, like sedans, station wagons, pickups, sports utility vehicles. And it specifically excludes, as a matter of law, excludes motorcycles or large vehicles like trucks, buses, other heavy equipment. So the Philippine Lemon Law is one such law that pertains to brand new motor vehicles, and it was enacted in 2014. And I think interesting to note that this is over 10 years from the enactment of the more generally applicable consumer protection law, which is the Consumer Act of 1992. As to the question of why legislators felt there was a need to enact a Philippine Lemon Law, even as there was already in existence a generally applicable consumer protection law, well, could very well have been, and on this I speculate, that there was a perceived need to have a special law that applied to brand new motor vehicles, considering the importance in our culture, in our society, of vehicles to individuals and families. In fact, the law itself says in its declaration of policy that the state recognizes a motor vehicle as a major consumer purchase or investment, and thus rights of consumers should be clearly defined, including their means of redress of complaints.
And then, Joey, you mentioned the Consumer Act of the Philippines, or RA number 7394. How is it different from the Philippine Lemon Law in terms of protection afforded to buyers of defective or faulty goods?
Well, as I mentioned earlier, the Philippine Lemon Law focuses as a subject matter on brand new motor vehicles. So the main difference between the Philippine Lemon Law and the Consumer Act is that the former deals specifically with that subject matter, exclusively with that subject matter, meaning brand new motor vehicles as defined in that law. On the other hand, the Consumer Act is one that affords protection to consumers in general for just about any product or service that they acquire. There are also differences between the two laws insofar as the requirements and procedures for asserting one's remedies against the service provider or the product supplier. Although in the assertion of remedies, both laws provide that the Department of Trade and Industry is the principal administrative agency that is in charge. Both laws also provide the main remedies of consumers ultimately in complaints about defects in products or services would be replacement or restitution as well as damages.
And just to be clear, both laws are in effect, right? So that's really important because in the case of DTI versus Toyota Balintawak, that's really the bone of contention here. Which law do you apply? But before we go to the details, Dean, what exactly happened here in DTI versus Toyota Balintawak? What were the key facts that led to the dispute between Marilu Tan and Toyota Balintawak?
Yeah, well, the key facts in the case of it's DTI versus Toyota Balintawak and Toyota Motors. It's actually very fairly simple and straightforward. So we do have Marilu Tan, who had purchased a Toyota Fortuner from Toyota Balintawak sometime in May of 2016. And soon after they purchased the vehicle, they noticed that the vehicle was exhibiting a jerky movement whenever they shifted gears. So concerned about that condition of the car, Marilu brought the car back to the dealer and inquired about what was necessary to repair the defect. So Toyota examined the vehicle and advised the transmission assembly had to be replaced or refueled. You know, I don't know much about transmission assemblies, but this seems like a pretty major job. So much so that upon hearing this, Marilu demanded a replacement of the vehicle or a refund. Toyota, however, informed Marilu that under the Philippine Lemon Law, as dealers, they were entitled to make at least 4 attempts to repair the defect in the car. Thus, they refused to replace the vehicle or give a full refund and instead offered to replace the transmission assembly at no cost to Marilu. Sometime months later, July 2016, which would be more than a month after the purchase, Marilu wrote to Toyota to inform them that she rejected the offer to merely replace the transmission assembly and that she would seek to enforce her legal rights as a consumer, which she did. Because on the following day, Marilu filed a complaint against Toyota with the Department of Trade and Industry, alleging that she had purchased the brand new vehicle, it was delivered to her, but that there was a defect, and that defect could not be replaced within an acceptable period of time. In Marilu's letter, she cites as the basis for her claim Article 100 of the Consumer Act of the Philippines, and in particular stated that since the defect was not corrected within 30 days under that provision of law, she's entitled to demand the replacement of the unit or immediate reimbursement of the amount she paid for the car. So, DTI, okay. So, what DTI did and then decided was they required Toyota to respond. And in its response, Toyota asserted that the basis for Marilu's claim was inappropriate. He said that it should not be the Consumer Act that should apply, but the Philippine Lemon Law. And, the Toyota reiterated that in the latter law, the dealer is not liable for replacement or reimbursement until having been given opportunities to rectify any defect. As provided for in the Philippine Lemon Law. So this is the essential dispute. These are positions raised by both parties at the DTI. But it's noteworthy that during the pendency of the case with the DTI, the vehicle was actually successfully repaired by Toyota. But however, despite this, DTI went ahead and issued the ruling, and in its ruling, it sided in favor of the position asserted by Marilu and held that the Consumer Act applied. And thus, they directed Toyota to honor her rights, replace the vehicle, or pay the refund. So, expectedly, Toyota challenges this ruling by a petition to the Court of Appeals. And the Court of Appeals, in turn, ruled in favor of Toyota, reversing the DTI. The Court of Appeals asserted that the applicable law in the case should be the Philippine Lemon Law because it is a special law that governs brand new motor vehicles. The Consumer Act, on the other hand, is a general law for the purchase of computer products in general, consumer products in general, and on the basis of StatCon, statutory construction principles, special laws should prevail.
So it seems like it's really a battle here between which law will apply. With, of course, you can imagine if you were in the case of Marilu Tan, the reason why you would choose the Consumer Act is because it's more favorable to you, presumably because of the procedure under the Lemon Law. What steps should a buyer take under the Lemon Law before he could ask for a refund or replacement of a defective vehicle?
Yeah. Well, under the Philippine Lemon Law, in order for a consumer to be qualified to seek a refund or replacement of a defective vehicle, there should, of course, first be a defect in the vehicle, and in the vehicle that was purchased. And that defect would be generally anything that does not conform to the specifications of the manufacturer or dealer, which renders it unsafe or unusable. But there are defects that are not considered qualifying for this purpose, and these would generally be defects that are caused by the fault of the consumer, such as not complying with warranties or making modifications that are unauthorized or to acts of force majeure. Now, if there is a defect, if there's a qualifying defect under the law, within a period of 12 months from its purchase or 20,000 kilometers, whichever comes first, the dealer must be given a chance to repair the defect at least in 4 attempts. And if it is unresolved, then the consumer should send to the dealer or manufacturer a notice that it intends to avail of the remedies under the Philippine Lemon Law. After submitting the notice of that kind of notice, the consumer must bring the vehicle to the manufacturer or dealer for one final attempt at repair, and if it is not sufficiently repaired, then they can proceed to file a complaint before the Department of Trade and Industry. So that's essentially the procedure. But note that in addition to this recourse, while the vehicle is not able to be used, the law requires the dealer to provide compensation to the consumer by way of providing a service vehicle or amount corresponding to that which would have been spent if, based on an aircon taxi rate, that the consumer would have incurred in transporting himself or herself to and from his or her home to his or her office.
And Dean, I'm curious, is this provision only in the Philippine Lemon Law or there's nothing like this in the Consumer Act?
Yeah. The Consumer Act doesn't have a specific comparable provision about, providing that kind of compensation, particularly in the provision of the Consumer Act that was cited by the Department of Trade in support of the position of Marilu then, which was that, the Section 100 of the Consumer Act, which essentially says restitution, reimbursement, etc., etc. There's no similar mention of providing service vehicles, etc.
And it's interesting that the DTI and the Court of Appeals actually have differing interpretations of which laws to apply. So you've explained earlier, Dean, why the DTI and the Court of Appeals decided that way. So when it went to the Supreme Court, how did the Supreme Court finally resolve this particular issue?
Yeah. Well, the Supreme Court, took note of several issues preliminarily, which was that they took note of the fact that, the car was repaired.
Yes.
While they're all litigating this thing, the car was repaired. So the obvious question was, isn't this moot?
Right.
Isn't the case moot? The party is satisfied, they received the car, it's been fixed. So isn't it moot? And the Supreme Court, in fact, like the Court of Appeals, did concede that on its face, it's moot. Okay, because again, the party was already satisfied with the repair of the vehicle, and yet they decided, however, that this is the type of ruling that we should still nonetheless issue as an exception, because these are the kinds of cases that could very well repeat and not come to the court, and therefore not be subject to judicial review. So first of all, I guess decided we will still continue to rule on the case, no?
Right.
Even though that it might be considered as moot and academic. So the Supreme Court ruled that the Philippine Lemon Law is not an exclusive remedy for aggrieved consumers, the ones who purchase brand new motor vehicles. Supreme Court held that the enactment of the Philippine Lemon Law did not operate to amend or repeal the Consumer Act with respect to brand new vehicles, even if it is conceitedly a later law and a special law. They took note, actually, of the express provision in the Philippine Lemon Law that states, and I quote, "Nothing herein shall be construed to limit or impair the rights and remedies of consumers under any other law." And so, according to the court, that other law in this instance would be the Consumer Act. So even if the Consumer Act was a prior law and provides for a different set of rules for the exercise of remedies by consumers, it continues to be available to consumers as an option to select from. So when it comes to defects in brand new motor vehicles, according to the High Court, consumer can choose between the Philippine Lemon Law and the Consumer Act, as both remain to be in full force and effect.
So whose determination, Dean, will matter here? It's the choice of the complainant, it seems.
It
from
looks
this
like it's the
decision.
choice of the complainant. I think one of the interesting aspects here is that while the Lemon Law, like the Consumer Act, is one that is touted to be for the protection of consumers, the Philippine Lemon Law also actually gives certain prerogatives and reliefs and leeways and spaces to car dealers and manufacturers,
Right.
in that their obligation to do any reimbursement or replacement of vehicle is conditioned on giving them a chance,
Right.
giving them a chance to repair, which is again not found in the Consumer Act. The Consumer Act is like a passage of time. 30 days pass, well, you can be compelled to reimburse or to replace. In the Lemon Law, there's breathing space for the car dealers and manufacturers. But at the end of the day, it's the interests of the consumers that were upheld, I think, precisely because there was an express provision of law
Right.
that reserved the applicability of the Consumer Act.
And just to be clear, Dean, because if you look at the discussion in this case, it would seem that Marilu Tan was correct in her contention all along, right? That she could invoke the Consumer Act. But because of certain peculiarities in this case, you mentioned it was moot and academic because it was already repaired. And in fact, the court also pointed out that the DTI secretary was not the proper party to file the petition. So eventually, Marilu lost this case. But for future cases, would you say that this is a really important decision with respect to the rights of the consumers? And how do you think the court will balance this protection of the rights of consumers vis-a-vis the interest of car manufacturers or dealers?
Well, I think it's an important ruling, even just for the clarification that it gives, that insofar as the existence of these two laws are concerned, they continue in full force and effect, side by side. It's clear now that the consumer has the right to choose that. In terms of the manufacturers, well, I don't know. Because effectively, insofar as the perspectives of consumer is concerned, the tendency would probably be to prefer the law that will give them the faster relief with the less cumbersome requirements, no? Which seems to be the Consumer Act. No? But again, ruling on this case, which is again supposedly a moot case, I think one of the underpinnings to this kind of approach, I think, is that it does recognize, remember that I think it's Article 8 of the Civil Code, that judicial decisions form part of the legal system in the Philippines. So therefore, this case, even as the parties themselves do not derive any relief from it, will have precedent effect. So even though a case might be rendered moot or academic, the value of the case, insofar as providing guidance to the public, is also an important consideration. So I think that's the import of this particular decision. And as an important consideration also, insofar as the Supreme Court's perception is concerned, the express language of the law that says that the Philippine Lemon Law does not in any way impair the rights of consumers available under any other law. It meant what it said. And therefore, court has no other choice to apply the law. So it's a case that, number one, is of value even though it's moot because it provides guidance, and it also reaffirms that the law is the law and has to be applied based on what it says.
Right. And finally, Dean, just as a final note to our listeners, what should be our key takeaway from this discussion of the Philippine Lemon Law versus the Consumer Act? And this is perhaps beneficial not just to those seeking to buy brand new vehicles, but maybe also other goods as well.
Okay. If you allow me, I will categorize, I suppose, by key takeaways.
Please go ahead.
Into lessons for manufacturers, dealers, and distributors of brand new motor vehicles on the one hand, for consumers of these brand new motor vehicles on the other, and lastly, for legislators.
Yes.
So I think, I'd probably sum it up as follows. I think the first key takeaway or lesson from this for car dealers or manufacturers is, of course, don't sell lemons. Make sure that the vehicles you sell conform to the specifications so that you avoid having to go through what Toyota had gone through in this particular case. While you might take some leeway in, some comfort, in the leeways provided by the Philippine Lemon Law, this case tells you that the Consumer Act remains to be available to consumers, and therefore you have to be prepared for the consequences. You have to expect this kind of reaction from people who are aware of this case. Again, really, because as far as I can tell, the Consumer Act seems to provide the faster and easier remedy for consumers. So again, be prepared for car dealers. For consumers, I think the obvious lessons would be to be fully aware of your rights as consumers. You pay good money for products and services. So, and this includes brand new motor vehicles. You should be able to reap the full benefits of that which you acquire. So take a look at the specifications of your brand new motor vehicle, examine the warranty booklets, know your rights, and in the event, trust that the law is there to protect you, these consumer protection laws. And also be familiar with transmission assemblies. And lastly, I think for legislators, I think the key takeaway is that words have consequences. So the statutory construction principle about, repeal of inconsistent or earlier laws is so well entrenched in our system. But even though these principles are very well settled, as can be seen in this case, where you include language that negates these principles, it will be given effect. I trust, of course, that this sentence in the Philippine Lemon Law, which the Supreme Court relied upon, was deliberated and intentionally incorporated. But if it were not, then this certainly is a lesson or a reminder again about how consequential the language of the law is.
And would you advocate, Dean, that perhaps there's really a need to look at the existing laws and how they might conflict or perhaps interfere with the implementation of a proposed legislation?
I think that's always necessary. It's always necessary to review past legislations whenever you are crafting legislation, because there's always that possibility of unintended consequences, where you feel, for instance, that there's no inconsistent law because that's as far as you recall, and again, by a lapse, there apparently turns out to be one, then you don't deal with that situation. So I think lawmaking, I've never been a legislator, of course, but I think lawmaking necessarily comes with both, the substantive aspect of what you are legislating, etc., but a look back at what's existing out there that you might have to contend with the law that you're enacting. So that's, I think, really part of the process.
All right. Thank you, Dean. So much to learn from this discussion today. So thank you again for joining us, Dean Hofileña.
Thank you. Thank you, Mike. My pleasure.
And if you wish to read the full text of the court's decision, please visit the Supreme Court website and e-library and search for Department of Trade and Industry versus Toyota Balintawak Incorporated and Toyota Motor Philippines Corporation, GR numbers 254978-79. Here's Stiff Atendido Beltran, Supreme Court Information Officer, for this week's updates.
From the Supreme Court of the Philippines, here's the latest. The Supreme Court has denied the motion filed by officers of the Philippine Army, Philippine National Police, National Security Council, and the National Task Force to End Local Communist Armed Conflict, questioning the writs of amparo and habeas data earlier granted to environmental advocates Junila Castro and Jedriana Tamano. In a resolution written by Associate Justice Ramon Paul Hernando, the court en banc upheld its October 2023 decision, which issued the writs, along with a temporary protection order or TPO, in favor of Castro and Tamano against the respondents, whom they accused of abducting them. Respondents challenged the Supreme Court's finding of substantial evidence, which according to them should be adjudicated by the Court of Appeals. They also claimed they were denied due process when they were not required to comment. The SC explained that under the rules, the writs of amparo and habeas data may be issued outright if on the face of the petition, it ought to issue. But the amparo and habeas data rules also allow courts to recognize stronger proof when it exists, such as substantial evidence to justify the immediate issuance of the writs. The SC noted that the CA had denied the privileges of the writs of amparo and habeas data, which the two environmental advocates are now challenging before the SC. It directed respondents to file their comment to ensure the complete resolution of the case. Senior Associate Justice Marvic Leonen on Tuesday, December 9, challenged government workers to prioritize addressing corruption. Speaking at the National Anti-Corruption Summit, Sikhay Laban sa Korupsyon or SILAC, held in Pasig City, Saj Leonen encouraged stakeholders to demand and expect more integrity from our leaders, including justices and judges. For the judiciary's part, Saj Leonen vowed that it will maintain integrity and hold all other institutions within our legal order accountable, citing reforms in the judiciary, such as the 2025 Code of Judicial Conduct and Accountability and the Code of Conduct and Accountability for court officials and personnel, and the designation of several regional trial courts as anti-graft courts. SILAC Initiative is the Office of the Ombudsman's advocacy platform against corruption. Also on Tuesday, Associate Justice Maria Filomena Singh underscored that each development comes with an obligation to ensure equal access and benefit to all at the year-end stakeholders meeting of the Legal Education Board or LEB held in Pasay City. Addressing LEB members, representatives from law schools and stakeholders, Justice Singh discussed reforms such as the digitalization of the bar examinations, translations of pressers on latest jurisprudence in Filipino and Bisaya, and an upcoming decision on a tax case which she penned entirely in Filipino. An educator at heart, she reiterated that legal education must prepare the youth not merely to know the law, but to use it wisely, ethically, and courageously. Meanwhile, on December 8, the Office of the 2026 Bar Examinations Chairperson, Associate Justice Samuel Garlan, announced that the application period for the 2026 bar examinations will open on January 8 and will last until March 9, 2026. Information on documentary requirements for new applicants, previous takers and refreshers, and venue selection may be found on Bar Bulletin Number 2. The Office of the Bar Chair also released the Barista User Guide, a comprehensive video tutorial on the entire application process for the 2026 bar. Meanwhile, the Office of the 2026 Sharia Special Bar Examinations Chairperson, or SSBE, Associate Justice Henry John Paul Inting, has announced that the application period for the 2026 SSBE has been extended until December 17, 2025 at 5 o'clock in the afternoon. Full details may be found at the 2026 SSBE notice. On December 9, the SC opened the application for accreditation of Electronic Notarization Facility or ENF providers with the SC Electronic Notary Services. As provided by the rules on electronic notarization, ENF providers must possess the minimum requirements to be accredited. Applications and requirements may be submitted via the ENF Provider Accreditation Portal link. The Supreme Court mourns the passing of retired Associate Justice Bernardo P. Parno, who served the court from October 1998 to February 2002. He was 93. Prior to his appointment to the court, Justice Pardo was a former chairman of the Commission on Elections, Court of Appeals Associate Justice, Court of First Instance and Regional Trial Court Judge, and Acting Assistant Solicitor General. He also served as chairperson of the Mandatory Continuing Legal Education Governing Board. The SC condoles with the family and loved ones of Justice Pardo. You are now up to date with the Philippine Supreme Court. I am Atty. Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast as well as previous episodes on the Supreme Court Public Information Office's accounts on Facebook, YouTube, Spotify, and Apple Podcast. This podcast episode was produced by the Supreme Court Public Information Office, with Attorney Mike Navallo as overall in charge of production, Attorney Karen Martinez as supervising producer, J. Rempilio, executive producer, Tiff Atendido Beltran, producer, May Sibal, Attorney Ayan Aldueso, Attorney Sheila Reyes, and Ramir Simbahon as researchers and writers, Brian Austria, Don Ryan Balza, and Vini Laraño as audio editors, Lawrence Olaño and Austin Aliscat as video editors, Bea Batong as graphic artist, and Tyke Flores and Jerome Batumalaki as web editors.